This is why wills matter in blended families. Watch till the end to see why. This is a case about a man called Stanley who died in 2020, aged 91. Stanley had a complicated personal life. He was first married to Agnes and had 3 children, Ronald, Martin and Jennifer, but separated from Agnes in the 80s. He moved in with a woman called Kathleen. In 2009, Stanley was sectioned under the Mental Health Act and diagnosed with Pick's disease, a form of dementia. He and Kathleen separated that same year. Between 2009 and 2020, Stanley made 6 wills, constantly changing who got what. In 2010, he left half his bungalow to Kathleen's daughter, Diane, and half to Martin. But after Kathleen died in 2014, he made a new will a few weeks later, cutting Diane out completely, despite having given her the deeds with a handwritten note saying, "Di, keep safe, you're half of the house." His final will, signed through a car window during COVID lockdown, left everything to Jennifer and Ronald, and to his grandchildren. He excluded both Martin and Diane. After Stanley's death, Diane challenged the later wills, arguing that his constant will changing was evidence his dementia meant he lacked testamentary capacity. If she succeeded, the 2010 will, giving half the bungalow, would stand. The court applied Banks and Goodfellow, but the judge also tackled a bigger question that had been causing real uncertainty. Does Mental Capacity Act 2005 replace this Victorian-era test? His answer was no, but the 2 tests aren't in conflict either. He found that the Banks test still governs probate cases, but the MCA can be used as a cross-check alongside it. This brought welcome clarity to an area where lawyers genuinely disagreed. On Stanley himself, the judge found he had capacity for every will from 2010 onwards. Despite the dementia diagnosis, Stanley gave rational explanations for his choice at each stage. As the judge memorably put it, Stanley's constant will changing had more to do with his caprice than capacity. Making harsh or even callous decisions doesn't mean you lack capacity. The case settled mid-trial, but the judge delivered this judgment specifically to clarify the law for future cases. If this made you think about your own plans, you can get started through the link in our bio. Follow to stay informed.